Hello, and welcome to another U.S. Tech Workers podcast. Today is May the 2nd, 2019, and I am your host, Kevin Lynn. And today I am joined by John Miano. Now, John is an attorney. He works for the Immigration Reform Law Institute. He is also a former tech worker, and he is an author, too, who has written extensively about the issues regarding employment visas and their impact on our skilled labor. John, welcome to the show.
Hey, Kevin.
Great to have you back. The last time we got together, I think it was one of our best performing podcasts. So great to have you back, John.
Well, it's great to be here with you.
Well, let me lay some groundwork because we're going to talk about something that's timely and top of mind with many tech workers, a lot of our audience out there. Yesterday, there was supposed to have been a meeting at the Office of Management and Budget, and they were going to review a rule to rescind the H-4 EAD program, which allows spouses of H-1B visa holders to work here in the U.S., and that's about 90,000 people. Now, I guess, it being reviewed by OMB is part of that regulatory bureaucratic process. But I know, John, you have had some concerns with what has been coming out of DHS in terms of the let's just say their enthusiasm for seeing it rescinded. But more importantly, John, with Save Jobs USA, you have a lawsuit filed on this. So in a way, if we don't get this via the government, we might get it through the courts. And I'd sure like to get your input on all this. So take it away, John.
Well, I think the big picture is, Trump campaigned that he was going to protect American workers, that he was going to end some of these Obama work authorizations. Probably no president hated American workers more than Barack Obama, and he used the regulatory system to allow a flood of foreign workers into the United States with a number of regulations, without even any approval from Congress.
And we see that with the decline in the labor participation rate. We see that with actual declining wages, even though we've seen reports pop up every once in a while over the last year where, we're Americans are earning more. The reality is it's not making up for
inflation. Yeah, working Americans have not seen a pay raise since the 70s. We see all this growth. It all gets concentrated at the top. Disney lays off, replaces 250 Americans, H-1B workers. The president of Disney is making $61 million a year now. What we're seeing is, wealth concentration in the hands of few. And the expectation was that Donald Trump would do something about this. And unfortunately, Trump has put in place people who are not with his agenda, or at least that he ran with.
And what's going on with H-4 EAD is emblematic of that. Kristen Nielsen, fortunately, she's out of there, but Wolf, a couple others are still in there. Can you delve a little more deeply into that? This smacks of the deep state.
Yeah, I mean, for example, Trump appointed Kristen Nielsen as the DHS secretary. When he was elected, people thought it would be someone like Chris Kobach, who would do something. Instead, he appointed a Bush apparatchik, Kristen Nielsen. I mean, if you looked at her resume, she had no particular qualifications to be the DHS secretary. She made as her chief of staff a guy named Chad Wolf, who was a lobbyist for these H-1B body shops that specialize in replacing Americans. So they were
they put the fox in charge of the hen house.
Right. And Trump has nominated this guy, Chad Wolf, to be the head of policy for DHS, another promotion. So Trump, elected on one thing and then put, people who just simply word on the program that he ran on. And, one of the things is we have not seen a single Obama-era work authorization for foreign workers rescinded. Not one. And the only one they attempted was DACA for the illegal alien children. And what happened to that is the deep state within DHS took a dive in court. I mean, they sabotaged the court cases, so they lose, and DACA survives. In fact, there's was one of the cases is the NAACP versus Trump in the D.C. district. The D.C. district court notes in a footnote all these arguments that DHS could have made on the constitutional grounds.
They didn't make them?
They didn't make them. And then he said, well, since DHS didn't make them, we're not going to consider them. So even that court knew that DHS wasn't doing the job there.
Wow. They're literally shooting themselves in the foot on purpose when it comes to protecting U.S. workers. Wow, that's reprehensible.
So the only progress that's made in these work authorizations is when someone outside sues, like when the state of Texas ended the DAPA program. So we're hoping to do the same thing here with the H-4 employment, and I expect.
And that's with Save Jobs USA. Now, when was that lawsuit filed, John?
4 years ago.
Wow. And as it makes its way, it's obviously probably in the DC circuit. What's going on with it now? What can you update us with?
Okay, well, originally it was filed in the district court 4 years ago. In the district court's decision, they held that the U.S. workers did not have standing, which is
in our own country we don't have standing.
Yeah, so it's kind of funny because in this case, the foreign workers had standing, but the American workers didn't have standing. It's quite a contrast. But the law of standing is a complete nonsense. It's not even law. It's complete. I wish
Isn't that a way to just kind of weed out the cases the judge doesn't want to hear?
That's effectively what it's been turned into. If you look in there was the case of Washington versus Trump. That was where the state of Washington challenged the so-called Muslim ban, and the court, and there's a video of the hearing, and an hour and 1 minute into it, the judge says, it's a very interesting question whether these plaintiffs even have standing, but as all the attorneys in the room know, the law of standing is murky, and then he goes on to find standing for them. So the murkiness allows standing, for people to pass completely unimpeded if the judge wants it to. But when American workers bring cases like this, the murkiness turns into a giant hurdle. I mean, we literally in every case, do 30 pages of briefing, twice at 2 stages in the district court, and then in the Court of Appeals, arguing things that have already been decided. I mean that in this case we argued competitive injury. There are more of these foreign workers. You get this is a standard way of getting.
There's plenty of information, law on that, correct?
Yeah. Oh, I mean it's nuts. I mean I did it's overwhelming in favor of standing. You would think it's settled law, but every time I go into the district courts with alleging competitive injury, it's as if this is a brand new novel theory that I've invented, and we have to. And you argue it, as if you invented it, even though you have 50 years of case law and citations. As a kind of exercise in this case, I made up one giant citation of just Court of Appeals cases that supported standing. It was 7 pages long, just a citation.
Wow.
You have one opinion.
I guess that's what you have to do in these situations. You have to go into overkill mode. So, when do you think you'll actually, you've obviously been in front of the judge probably several times over the last 4 years. When do you think you're going to have your day in court?
Well, what's happened again is the district court found there was no standing, and then also found the rule was lawful, which is kind of an interesting thing about standing. Is there are lots of opinions where a district court finds that the plaintiffs didn't have standing, but if they did have standing, it would have found against you. There are no opinions that say you don't have standing, but if you did, I would have found for you. So now we're on to appeal to the D.C. Circuit, and then the first issue again is the standing thing, which I've argued repeatedly the exact same things over and over again in the D.C. Circuit. Fortunately, they've always given the same answer, so we're kind of expecting they'll give the same answer again, and standing isn't really an issue. The big question is whether they'll address the merits, because the district court, in theory, the district court can't make a formal ruling on the merits if there's no standing. But the district court went on and said, well, if we did have standing, this is how I would rule against you. So it's the D.C. Circuit can, because this is just a question of law, is it legal, address the merits. And we're hoping.
Okay, so they'll say, yes, you have standing on your appeal, and then they'll say, okay, let's discuss the merits then.
Right. And that's what they'll hopefully do, especially after this thing's been dragged out for 4 years.
Golly. So do you have any idea that timeline? Because obviously what's going on, I have no information what happened at Office of Management Budget yesterday. I don't think you do either. But that could take 60 to 90 days to play out, because I think they have to publish their views and they got to go back to DHS. When do you think, if your lawsuit if you're able to move forward with the suit, when do you think you might have some closure there?
Well, it's kind of up to the court. So far, they've not scheduled oral argument, and they're scheduled up to May the 13th. So it could happen, sometime after that. We just don't know when they'll put it on the calendar, and then it usually takes them 2 months to put out an opinion. Okay.
Okay.
It usually, but sometimes might take 6 months. So it's kind of up to them when they do it. So, but anyway, it'd probably be fast. A court decision is certainly, if the court were to decide the merits, a court decision would come down faster than DHS possibly even doing this regulation, which I don't even think is ever going to come about.
Okay, so you don't think that they'll ever get around to rescinding H-4? Now, the scary thing is, if they don't rescind it, does that kind of become a fact of law, where it's like, well, it's okay for spouses of H-1B visa holders to be working in the U.S.?
Well, it would, unless the courts strike it down. Okay.
Okay.
Then it would be. But even worse, it wouldn't be just the spouses. Remember what the Obama administration claimed, and which Trump's DHS still claims, is they have absolute unlimited authority to allow any class of aliens to work in the United States through regulation, unless Congress explicitly prohibits it.
My gosh.
So that's
how far we've come from the mid 1920s, where they understood it was about supply and demand, and that the chambers of commerce, the ethnic lobbies, were the ones that were pushing cheap labor onto the U.S. market, and it was at that time the populace that rebelled and took over Congress and made those changes. My gosh, how far we fall.
Well, it is a great fall, because notice that in the class of, let's just say, the college-educated labor, Congress gave industry 3 increases from 1998 to 2004. They were just bending backwards. The rise of the internet, they were just jumping up and down. But after 3 times, they were kind of,
right,
guys, this is enough. Okay?
Yeah.
So what they've now done is they switched to using regulation. Okay? So there's been huge increase in the amount of foreign labor coming to the United States through regulation over the past 10 years. For example, another case that we have is over the OPT program, the litigation which has been going over for 11 years.
Yep.
A simple question of, is this legal, has been dragged out. The federal courts have managed to drag this out to 11 years.
Yeah, and for those who don't know what OPT is, it stands for Optional Practical Training. It's a visa program that allows a recent foreigner that graduated from a U.S. college to remain in the U.S. for, is it 24 months, John?
Well, if they're in a STEM field, quote STEM, science, technology, engineering or mathematics, to use the lobbyist speak term, they can actually stay up to 42 months now.
Wow. And the thing is, what's amazing, John, and this is at a time when only roughly a quarter of STEM graduates are working in the fields that they studied in. And companies, universities, as well as private companies and public companies, love OPT because they don't have to pay Social Security taxes. They get a 15% benefit right off the bat. I know when you look at J1s, OPTs, universities love them because they get a quiescent labor force, essentially, that's happy to sleep on the floor of the labs working 80 hours a week. This is crazy what's going on.
Well, it's interesting that in 2007, at the end of the Bush administration, DHS, Microsoft threw a dinner party for the DHS secretary, and to expand the OPT program to be a substitute for H-1B.
Oh my God!
Previously, it had only been 1 year. Basically an internship.
Well, essentially, it is, because they get them here on an OPT, and then they will sponsor them for an H-1B visa, which will give them the dual intent opportunity then to apply for citizenship. And what they'll do is they will make, they call, you refer, the term unicorn. I'm really saying this for our audience. So they'll make a job, put out a job notice that's tailored to the experience of that OPT holder. It's crazy. They lock our kids out from getting jobs out of college, and they ensure that they never get into the workforce with these programs. Right.
Well, it's interesting that after Microsoft got this as a kind of workaround to the H-1B quotas, we now have more people entering the workforce through OPT than H-1B.
God.
So, so this started, was a way to get around the limits. Now it's even bigger than the limits. So this is huge. What's going on, and the implications, are big for the DC Circuit here, because if they were to affirm that this H-4 employment is lawful, then American workers have no protections whatsoever anymore in the immigration system, because anything Congress does can be undermined by a regulation from Congress.
Wow.
Well, it's kind of funny in the opposition briefs, they say, "Oh no, that's not, because Congress can block a work authorization." But Congress would because of the veto, the Congress would have to have a 2/3 majority to block the measure. Okay, so so in other words, Congress, it takes 2/3 majority for Congress to create a work authorization that the president wants, 2/3 majority for them to take away a work authorization that the president wants.
And we know they're never going to do that.
And the executive then has a greater power over immigration than Congress does, according to this system. And it was quite eye-opening to read some of the responses that were submitted to the court describing how the immigration system works in order to justify H-4 employment. And it was just mind-boggling. This is what you're saying here is completely unconstitutional.
Yeah, and H-4, there are no restrictions on what jobs that spouse can have.
No. And look at the sense. What sense does this make? Because you're sitting there. In theory, H-1B workers are here filling jobs Americans can't do. We know that's baloney, but that's what we're told. Okay, if they're filling jobs that Americans can't do, and they're working subject to a labor condition application, then what's the point of letting the spouse work willy-nilly? It's only the strongest, weakest link.
The chambers of commerce love it, and the reality is, anyone who comes to the U.S. Gets a reality check really fast. There is no such thing as, you can't raise a family on one income here in the U.S. unless you're one of the elites. You really need those two incomes. That's one of the reasons why we haven't had a wage increase, as you mentioned earlier, since the 70s. So and add to that the fact that it's not so much that workers are being exploited, they're just becoming irrelevant in the face of AI and automation. So all of these things are coming together to really bludgeon the U.S. workforce. And no one, I was at an event today, and I really had to leave early because the proletariat in me was just rising, where there are these, there's so much delusional thinking going on about, this technology and how it's going to save us. It's like, no, we really need to step back and ask, what is this going to do to the worker who basically who raises the family? And when we take that away, that ability to work and ply a trade, or we that's an area I don't think we want to go there.
Well, remember back, if you're going back a few decades, the public was told we'll get rid of all our manufacturing jobs that provide the middle class wages, and we'll move into the technology jobs, and we'll use them. So
right.
We'll send the manufacturing jobs overseas, and we'll do the technology jobs. But then they do that; they've wiped out the manufacturing, and now they then say, okay, well now we need to replace the Americans with foreign workers. So in the technology jobs, the technology jobs are being taken away as well.
That's exactly 1992. The propaganda was there are jobs that don't have an economic right to exist, and that we sent our manufacturing base overseas, and we were told that, just like you said, we were going to have these information age jobs. Well, they found out how to keep those from us too, because on one hand they outsource and then they insource. Yeah.
And they also changed. It kind of changed the nature of the immigration system as well. That if you look at the congressional statement of purpose, for example, a student visa. The purpose of student visas was to bring foreign students to the United States so they could learn about America, then go home and take what they've learned about America to their countries and be ambassadors. Okay, and if you look at all the congressional reports on provisions governing student visas, that's the thing they were saying. We're always expecting these people to go home. Now we're sitting there, staple a green card, transform a student visa into a mechanism to stay permanently.
The 2008 vice presidential debate. Biden was like, "Oh my gosh, we're graduating these students who, by the way, are sitting in a slot that an American didn't get because of foreign students sitting there. Oh, we got to keep them here now."
Sure. And a similar one, you look at the the House report on the Immigration Act of 1990 that created the H-1B visa. They sit there and say that this is supposed to be a stopgap measure, a temporary thing to fill jobs that Americans can't do. That using foreign workers should be a last resort. Okay, it does use that term. It should be a last resort to hold on. Well, now it's been transformed. It's not. We're bringing foreign workers in the last resort. We're bringing foreign workers because we have a global market for talent. That employers should be able to shop anywhere over the world to bring in workers.
Absolutely, this is the whole philosophy of neoliberalism. It is the movement of money, capital, and people across borders. Borders just inhibit that. They inhibit the profit that these corporations can make. It's madness. And then you add to that our invade and invite paradigm. It's really insane what's going on. And John, I got to say, I really appreciate that you're out there fighting this fight. I know you were saying earlier, a couple of weeks ago, that you were up to your eyeballs in filings over all this, and I can well imagine that the midnight oil you're burning. But thanks for doing that. And to our audience, go to Amazon. Find John's book, John Miano's book, Sold Out. It's brilliant. If you want to understand what has happened with regard to how U.S. skilled labor is being displaced, that's the book.
And you should mention my co-author, the beautiful and intelligent Michelle Malkin.
Oh, there you go. And she's pretty much a regular on Fox News, isn't she?
Yes.
Fantastic. Well, John, is there anything else on the H-4 EAD program you'd like to share with our audience?
Not yet. I think we've covered it pretty well, but when the court, if we get a court decision, and said that might be 6 months from now. I mean, it'll have major implications on the future of immigration in the United States.
Well, great. Best of luck there, because it's looking like our last hope is going to be your court case, because the Jared Kushner Koch brothers wing of the White House seems to be hell bent on displacing Americans by expanding our employment visa programs.
That's right.
Thanks again, John. Take care. And to our audience, this is going to be posted to YouTube and Podbean. If you're on YouTube, please give us a thumbs up, comment, share, and visit us at www.ustechworkers.com to be updated. Take care now.